Hey guys, and welcome back to the Yes Means Yes podcast. On this week's episode, we are talking with Associate Attorney Mallory Harper from Agricola Law about sexual harassment and workers' rights. We're also going to do a little segment after that where we just share sexual harassment stories that have been shared with us via social media and other channels. But as usual, my name is Faith Nomchef. I am the prevention educator with Rape Counselors, and I'm going to let Brantley and Mallory introduce themselves.
Hey guys, I'm Brantley Shields. I am the outreach coordinator here at RCEA. I'm also a victim advocate here. Mallory, do you want to take it away?
Sure. My name is Mallory Harper. I am an attorney from Auburn, Alabama. I work for Agricola Law. We are a law firm located in downtown Opelika.
Awesome. Well, we are just so glad to have you here, Mallory, today to talk about workers' rights and stuff. So this podcast is going to be dealing specifically with sexual harassment in the workplace. So what is the legal definition of sexual harassment?
So sexual harassment, really in terms of how it relates to the workplace, is mostly governed by the EEOC. So it's Title VII of the Civil Rights Act. So the Title VII is actually what defines sexual harassment, and they give a definition that it's essentially just any unwelcome sexual advances, requests for sexual favors, any sort of, and that can be verbal, physical conduct and of a sexual nature, and it really is in the context of when that conduct is made upon an individual and that person, rejects it or does not want it. To such an extent where it interferes with the workplace, whether that's interfering with that individual's work performance or if it's creating like an intimidating or hostile work environment. So that's the general definition. And I do want to go ahead and introduce, this is Barbie Agricola. She's in here as well now. She owns the firm of Agricola Law.
Hello. Okay, so the second question we have is, are companies legally mandated to have a sexual harassment policy in place?
So, no. I did a bit of research because I was curious about this question as well. They're not mandated federally. So I talked about the EEOC. The EEOC actually recommends that companies have some sort of policy or regulation in place. But really, it's just left up to the states. So some states do actually have mandates requiring that companies have some sort of like anti-harassment policy. But mostly those states are up north, out west, like Connecticut or New York, the bigger states like that. But Alabama does not. So it's recommended by the EEOC, but not mandated.
And the other thing is, that's kind of interesting about like employment cases, especially dealing with sexual harassment, is that, the EEOC is the federal agency that governs this sort of thing. And like Mallory was saying, the state has their own as well, but the EEOC only is in effect for companies that have 15 or more employees. So, especially in a small town like Opelika or Auburn, or, most of the towns in Alabama, there's might be 5 employees, or there might be, 3 people. It's especially, I'd say, in a company here locally, it'd be a big company if they had 15 or more employees, because, there's lots of just local mom and pop type businesses. I mean, and my law firm itself doesn't have 15 employees. So, that's only required, and a claim can only be made to EEOC about sexual harassment if it meets that criteria of having at least 15 employees, because then that gives the EEOC jurisdiction in order to come in and be like a governing agency. But I mean, of course, in the small context of like a small company, obviously, for example, like my firm, sexual harassment wouldn't be permitted, of course, but no, we don't have a policy or anything like that. So I think what a lot of local companies do is just, kind of when or when you think it's appropriate or what isn't appropriate, and how they kind of handle things from an HR perspective generally. So if there's like a write-up or a warning, or if it's so severe that it, demands termination immediately. That's how kind of things, in my experience, have been, resolved for companies that are less than 15 employees.
Okay, perfect. And to follow up with that, what rights do workers have in terms of sexual harassment and the rights to a safe workplace?
So, I mean, again, if they work for a company that has 15 or more employees, then the EEOC would be involved. The employee, if they've experienced any sort of harassment, they can file a complaint through the EEOC. And if they do that, that's referred to what's called a charge of discrimination. They have 180 days to get that done. And then what that does is it formally requests the EEOC to come in and take remedial action against the company, or whatever the situation is. But in terms of rights, I mean, people have the right to be free from harassment and to be provided a safe workplace.
I think it's interesting that y'all brought up how the Equal Employment Opportunity requires the 15 employees. I did not know that before now, and I wonder what their basis is for that. Is it like, y'all know?
I don't.
I mean, know. I'm not. I'm sure. Of course, it doesn't say why, but I'm sure it likely goes back to the states having governing rights to up to a certain point. But of course, that would just be speculation.
I mean, and it could have something to do with like the number of like for insurance purposes.
That's also true, yeah.
So, and I mean, don't quote me on that.
For example, like workers' comp insurance, that's actually there's lots of things that you wouldn't realize. Like, so when my firm just started out, I had like 2 or 3 employees, and you're not required to have workers' comp insurance as a business owner until you have at least 4 or more employees. So I didn't get workers' comp until it was required, once I reached that threshold. So I don't know if it is an insurance thing or not, but that made me think of that.
Yeah, it could be just some sort of coverage eligibility. So
that's interesting, because I guess then that those, like, there's just no real governing over any of those small businesses like we talked about. And I mean, like you said, we know that there are so many places in Auburn, Opelika, all of these small rural towns in Alabama. So
yeah. And I think it also, because I think it's also, there's a benefit to the business owner as well, in the sense that it's already so difficult as a small business to stay afloat, that requiring to get workers' comp insurance and this and that, and it's business, all these different things. I think it's really designed, at least initially, to help small businesses with limiting their expenses. And then of course, as they grow and their expenses and their revenue is more flowing, and they have the ability to do that, then they've got, once they reach this threshold of employees, et cetera. So I don't know if that plays into it, but I think for sure it's beneficial from that regard.
Yeah, I would definitely think so. I mean, because if someone files an EEOC claim, then I mean, they have to do that before you can even file a lawsuit against someone. So if you're filing a lawsuit, then that opens up the company or to liability. So you could be talking a lot of money. So that's why companies get insurance, to prevent against that, or at least to cover that in case that happens. So it's probably all tied in together.
Yeah,
with that.
Okay, so I know y'all mentioned the law aspect, and that's kind of what we want to talk to you about, and just like your personal experiences. Have y'all ever worked on cases that are sexual harassment cases?
Yes, a great deal.
Okay, and is there like any common themes that come up that you see, that you work with, or is it like all just different?
It's all, sexual harassment would be one that of course has more of a common theme. But it's all kind of different. And oftentimes you've got, maybe the main thing is sexual harassment, but there's also like a little, maybe a little race, or maybe a gender discrimination is the technical term under the EEOC, and that's sexual harassment is a subset. there's always, almost always, whenever there's like a report about any of that within the company, like let's say, someone made an inappropriate comment, that person then goes, reports it, or says to somebody else, like, this made me really uncomfortable. And then there's always, like, if that occurs, oftentimes there's retaliation for making the report. So then that's also another claim that's included in the EEOC charge. And then sometimes we'll have cases where there's not any of the discrimination that is checked. There's boxes on the form, but just retaliation is checked. And so you can be retaliated against if you're engaging in a protected activity, a lawful employment protected activity. But it could be like not any of the discrimination things that are on the EEOC charge form for which the EEOC agency is, designed to govern over. But so we'll have cases where it's just a retaliation claim on the basis of, reporting unlawful employment activity. And then that person will then be retaliated against for making the report. So we have a lot of that. So I'd say almost exclusively, almost like 95% of the time, whenever we've got a discrimination case, we will always have retaliation with it. We will have cases where it's just a retaliation claim, but we almost always do have whatever the discrimination was with a retaliation claim.
Yeah, and we've seen that where someone has worked somewhere and they get performance evaluations and they have a history of excellent performance evals, and then an incident happens, whether it's a supervisor, it's usually a supervisor in this context, makes some sort of unwanted advance and that's rejected, and then the next time that a performance review comes around, that employee received this horrible performance review out of nowhere, and it's not related to any sort of work performance that they did or activity that they did. It's obviously directly related to the fact that they thwarted some sort of advance.
And or they'll do like maybe instead of having their exceptional, like we have a case I think you're probably referencing, where the employee has worked there for 15 plus years, always received exceptional, reviews every 6 months. She engaged in a protected activity, reported it, and then has been retaliated against. So then her reviews going forward were still good, but she did not get the 2% or 5% raise that goes with it every 6 months when you get above a certain number or above a certain grading or evaluation scale. And so she just didn't get that increase that she would have been entitled to under the company's rules and policies and what she'd been receiving for the past 15 plus years. Wow. So there's that too. It can be subtle, and actually if they're smart, if they're going to be sexually discriminatory or whatever, and they're smart about it, and they'll do it in a subtle way. But usually they're idiots and they're not smart about it, and they do it in a very overt way.
Yeah, it can be as subtle as something happening, and then that employee gets a new schedule, and they've been cut hours, and so that translates into they're making less money, or they get put on like a weekend schedule or something like that. It can be. That's still considered retaliation. So
awesome. That was all really good information. So if you were to give advice to someone who believes that they are experiencing sexual harassment in the workplace, what would that be? How would you advise them to go about resolving that issue?
Well, I would at least at first, it's very, very important that you document it. And depending on what the harassment is, what form of harassment is, depending on how you can document it, right? So if you have, if you can record it, if it's something verbal, or lots of times, sexual harassment happens and we don't know it's coming, right? So if you want to then go back and speak to the person who did that and record the conversation about how, listen, it made me really uncomfortable when you said this or whatever, or then recording the conversation when you go report that thing or that instance to HR. Do things in writing, sending an email to HR saying on such and such date, John Smith did this or said this to me, or Jane Smith did this or said this to me, and it was inappropriate, it felt uncomfortable. Do it in writing in an email, print that email out, because lots of times if someone's being retaliated against, many times that retaliation is termination. So then, of course, you lose access to your email account through the company. So if you print that, make sure you forward the email or copy the email to your personal email address, as well as to the HR department. So if any way of kind of documentation, whether it's emails, recordings, if you've got another witness who was present, and maybe you record a conversation with them, or you ask them to write a statement, a sworn statement, like an affidavit, where they, state they saw what happened and they're backing it up. Anything that documents it is really necessary in order to be successful if you want to take, the appropriate steps forward.
That's really good advice about forwarding an email to your personal account too. I don't think people would generally think to do that. So, and two, I'll mention in the state of Alabama, if so long as you are a party to the conversation, you can record and you don't have to tell the other person that you're actually recording. But you have to be a party to that conversation. You can't, record someone having a conversation in a room that you are not in.
Right.
So careful about that little legal
So
advice.
I could secretly be recording this conversation because it's a one-party state. So as long as one party to it knows, but if somebody were outside the door, that would be illegal.
Right.
So.
And to note, I heard you say it could be Jane Smith or John Smith. So obviously not just females are victims of sexual harassment. Males can be too. Statistically, I think that the scale tips a little bit more to one way, but that doesn't mean anything. Males can still be victims.
All right. Well, thank you guys. This has been super informative, and you guys have given us great information. Is there anything else that you can think of that you want to add before we sign off with y'all, or anything you think that's important for listeners to know?
I know lots of times when people come to us and they're, most of the time people are coming, especially with these types of cases, and they're like, listen, I'm not sure if this is anything, but I wanted to consult with you to see, right? Which is great. So if you think something is going on, do not hesitate to, reach out. And the most important thing would be the timing. Timing is critical to whether or not legal action can be taken regarding this, right? So, as Mallory referenced earlier, to file an EEOC charge, it's got to be within 180 days of the tortious conduct, right? So the day that you got, your butt was grabbed, 180 days from there. So if you don't go see anybody, or if you don't send the charge, until 200 days later, then, you're kind of, and you passed the window. And then the other thing is like, let's say your butt was grabbed on one day, but you're still working there for like 2 months, and then conditions get worse and worse and worse, and you either get fired or you quit because you just can't take it anymore. The harassment just accelerated. The last day of your job, right? So the day you were fired, that can be the marker for the 100-day, 80-day to begin. So just timing is so critical in these cases, and then the recording and documentation. Those are the two biggest things in that order.
Okay. Thank you guys so much for
thank you.
This was very helpful and a lot of information. Like you said, I wouldn't have even thought about the email forwarding or any of that. So yeah, I hope that anyone listening to this was able to get some good information out of it.
Yeah, and y'all feel free to holler at us. And if you've got questions, or if you've got new listeners who maybe made them think about things that have happened at work, they can absolutely give us a call, and we will talk them through it.
Awesome. And I will be sure to put the link to y'all's website and contact information in our bios, so that if they do need that information, they can definitely seek you. But thank you guys so much for joining us.
Yeah, thank you.
Thank y'all.
Thank you so much.
Y'all.
Bye, guys.
All right, so now we're going to go into the second segment that we have for our podcast today, where we're going to be sharing some stories of sexual harassment that we have received from coworkers,